Hey, good morning, everybody. Delighted to welcome everyone to another GCMA webinar, one of our rare live webinars now to enable people to ask questions of our speaker today at the end. For those watching on the recording, hopefully you'll also find this session very informative and interesting. Delighted to welcome this morning somebody I'm sure who needs no introduction by now, but we'll do it anyway. Alistair Smith, who's the Chief Executive of the National Golf Clubs Advisory Association. I know several of our members have been going to some of Alistair's in-person events across the country recently. And I know a lot of value has been gained from that. But the beauty of what we're able to do today is for those who maybe can't get out to a day at the moment because their clubs are too busy, or whether they've got some challenges with staffing, etc. We're delighted to be able to do this session with Alistair today, who's going to take us through all things employment law changes and everything else. So, Alistair, I'm delighted to welcome you. Thank you very much for joining us again. And I will now fade into the background and hand over to an actual expert. Over to you.
Morning, everybody, and thanks very much, Gareth. We've got quite a bit to cover this morning. The way I'm going to do it is with a PowerPoint slide, so I will share my screen first off, and that will hopefully mean that you can see what I'm talking about, and it's not quite as frantic in terms of trying to take notes. So, if someone can just give me the thumbs up that that's worked okay, yeah? Right, brilliant. Okay, so Employment Rights Act 2025. First thing to say is that it's labeled 2025, but most of the provisions are coming into force during 2026 and 2027. It was a bill before it became an act. It received royal assent on the 18th of December 2025, which is why it gets the label of 2025. It had what you could describe as quite a difficult progress through Parliament. It was knocked backwards and forwards between the House of Commons and the House of Lords with various amendments and requests for amendments and refusals of those requests for amendments. So it did take quite some time to get to where it was. It is a big piece of legislation. When it started its life as a bill, it was about 150 some pages. It ended up being 334 pages after various amendments and bits and bobs. The other thing to think about and remember about the Act as well is that it is 334 pages, it's big, but there are also supplementary pieces of legislation that follow from it. So there will be further regulations, further statutory instruments that come through during the course of the coming months and into next year that give further detail on it. So whilst this might have set up some of the framework, there is a lot more detail yet to come. As you'll see when we get further through this, there are consultations still ongoing at government level about what some of these areas will look like when they actually get the detail in the regulation form through the statutory instruments. So some of the things here we can just give you a broad idea. Once we get the detail, we can update you further on it. So we move to the next slide with any luck. Oops. Sorry. There we go. Sorry about that. So, as I mentioned, it came into force 18th of December. It is quite a big thing. What we'll do today is work through it and break it down. And it's quite easy to do that because each of the pieces of major change are coming through in stages at various dates. So we've got probably the biggest changes you will have seen would have been April 26, which are already in force. Next big one's October. Then we've got January 27 for the next big one. And then the rest of it to be confirmed. We'll have to wait a short while before the detail of when it's coming and the detail of what it will look like. So we'll work through all of that as we go through this morning. As we see there, the rough timeline for it, Stage one, we don't really need to concern ourselves with too much because that's all to do with trade unions and industrial action and what have you. We don't have to deal with that, luckily, in golf clubs. Stage two, as I mentioned, the April 26 pieces of change that are already in force and that I would hope that you know a fair bit about already. Then we've got October. That's the next thing to prepare for. Probably the biggest thing there will be the stronger harassment laws. January 27, it's unfair dismissal changes and fire and rehire are the biggies to look forward to there. And then further down the line, which should be probably the back end of 27, if not into 2028. I think the biggest thing there for golf club employers will be the changes to 0 hours workers, because I know a lot of golf clubs do rely on those 0 hours casual workers. So we'll circle back to what's already in force, which is changes that took effect on the 6th of April 26. So there you see we've got family friendly rights, SSP, we've got whistleblowing changes and some changes to protective awards. First one is paternity and parental leave become day one rights. So to set it in its context, we'll start firstly with paternity leave. So there's an entitlement to 2 weeks of paid paternity leave for new fathers, and it also applies to people who adopt children. In the adoption situation, they nominate which person is the primary adopter, and that person takes leave that's equivalent to a mother in a birth situation and is entitled to up to a year's leave. The other partner in the adoption situation effectively has the same rights as far as this is concerned as the birth father, and that's 2 weeks of paid paternity leave. Prior to this change, it was required that you had 6 months of continuous service in order to get your paternity leave. Now it's a day one right, so employees can potentially take paternity leave from day one. The little rub on this one, though, is that you still need to have 6 months of continuous service to get statutory paternity pay. So somebody that wants to take paternity leave from day one of employment up to that 6 month point, they can take the leave, but they won't get the statutory paternity pay. So what we might find in practice is that the new fathers, whether in an adoption situation or a birth situation, wait until they get to that 6 month point before they take their paternity leave so that they get their paternity pay. They are able to take that paternity leave at any time in the first year after the child's birth or after the adoption. So there will be scope for them to be able to do that. Moving on to parental leave. Previously, in order to take parental leave, an employee needed to have a full year of continuous service. It's now been reduced to a day one right. Some of you may be scratching your heads thinking, what is parental leave? And I wouldn't blame you because it's not a leave entitlement that many employees are aware of, let alone actually take. And what it is that if you have a child under 18, you can take unpaid parental leave, which is perhaps another reason why it's not as popular as otherwise it might be. You can take that parental leave and you can have up to 18 weeks of parental leave. And that can be taken, with a new child, you might decide I'll take 1 week of that 18-week entitlement per year, every year until the child is 18. The most you can take in any given year is 4 weeks in one block. So somebody might pile it all into 1 year if they have a particular issue and they want to take that all as one. But it is something, as I say, that's not massively known about, and it's something that has been there for years. But only change really is that now they can take it from day one. And it's worth mentioning while we're on this, because so few people know about parental leave, not to confuse it with what's called shared parental leave, which is a different entitlement. And that's something where In a birth situation, for example, the mother would normally be entitled to 12 months of maternity leave. Parents in that situation can share that leave such that the mother might decide to go back to work after 3 months. In that situation, the father can take the balance of the leave entitlement for the mother and take 9 months of shared parental leave for the remainder of that period. So that is something that maybe we see kick in a little bit more for those short-serving employees. Moving on to the next big change that occurred in April, and that is in relation to statutory sick pay. You may well have had experience of this if you've had employees taking their sickness absence. Previous system was that an employee on sickness absence had 3 waiting days before they're entitled to their SSP. Those are now removed so that somebody can get their SSP from day one of sickness absence. And the other big change was the removal of the lower earnings threshold, such that lower paid employees are now brought within scope to be able to claim this. A lot of the commentators and HR folks were expecting the possibility of that leading to a lot more sickness absence, a lot more ad hoc days from people, a day after a weekend or a bank holiday, they'll put in an ad hoc sick day. And it's a question of having to be able to manage that. And all we can say there is that's the law, that's their entitlement. The best way to manage it is to have a good, strong sickness absence management policy in place. And within that, you would set expectations, you would set what the rules are as to how much sickness absence somebody would be able to take before they might start facing some action from you in the way of disciplinary action, warnings, and that might help to reduce incidences of ad hoc sick days where it might be getting to be a problem for you within the organization. Again, like a lot of these policies and what have you, we've got one on our website if you need to have a look at that and to download it and put it into place. Next change that we saw in April this year was in relation to whistleblowing. Whistleblowing is a phrase that's thrown around a lot, but without perhaps everybody understanding the full detail of what it is. How it works in the world of employment law and unfair dismissal is that if an employee makes what's called a protected disclosure, then they get their protection from detriment. So if they were to be bullied or demoted or denied promotion within the workplace, they get protection there. And they also get protection from dismissal, in that if they are dismissed for having made a protected disclosure, it will be deemed to be, by the tribunal, if it goes to tribunal, it will be deemed to be an automatic unfair dismissal. So the employment tribunal won't be bothered about whether you followed a fair procedure, whether you had all sorts of investigations and fair hearings and gave them a chance to state their case and all this. If it is for a reason connected with having made a protected disclosure, then it will be an automatic unfair dismissal. One of the big issues with that is that it means that they don't have to have 2 years of continuous service. They can bring that claim from day one. So if there's a protected disclosure made, they're dismissed after having made that protected disclosure, then regardless of the length of service, they can bring an unfair dismissal claim. So that's where we are with the existing law. The list of what protected disclosures are is set out in legislation, and it includes the reason why this legislation came in way back when was because there'd been quite a number of high profile cases in the 80s and 90s where employees had been aware of health and safety failings in the railways or pollution, these sorts of things, and they'd been frightened to speak up and report it to either managers internally or to an external body. So the was changed to say you are protected if you do speak up about the fact that the rail infrastructure is dangerous because there's a lot of cracked rails, or because your employer is polluting the rivers. You've got protection from dismissal and from detriment as a result of it. So what changes now? It now includes any reports of sexual harassment being within the frame, such that if an employee reports sexual harassment, they would have that added protection from dismissal or from detriment. This particular addition was brought in on the back of the Me Too movement and the Harvey Weinstein cases and what have you. So it's to shore up the position to make sure that people feel comfortable to be able to report those types of things. And just a note as well, the Employment Rights Act does also have provisions in it to reform NDAs, which are non-disclosure agreements. So whereas previously unscrupulous employers may well have had an incident of sexual harassment, then they will do a deal through a settlement agreement to settle the claim, but they would also include a non-disclosure clause in there, a confidentiality clause to say you're not allowed to tell anyone outside of the organization about this. And if you do, we'll have all the money back that we've just paid you under the settlement agreement. So that is going to be subject to change such that you can still potentially settle the claim, but you can't stop them from disclosing it externally. That change is much further down the line in 2027. So we will have to see exactly how that works and what date it comes into force. There are some changes to collective consultation. Collective consultations in a redundancy situation, it applies where you are proposing to dismiss as redundant 20 or more people at one establishment. So I would expect that not to really touch the sides as far as existing golf clubs are concerned, because if you're dismissing 20 or more employees, I think the game's up and the club's likely to be closing. So we're hopefully not going to be having to deal with that particular change in any event. One further change, which came in April, but strangely was not part of the Employment Rights Act, is this entitlement to leave in circumstances where the primary carer dies. So if the mother were to die within 52 weeks of the birth, or the adopter, when there are two partners in an adoption situation, if they were to die within the first year of the child either being born or being placed for adoption, then the other partner would be able to take up to 52 weeks of leave. There is, at the moment, no scheme for payment during that term, which does seem to be a little odd and maybe just another place where, given the huge scale of this act, is something that they may end up looking to tidy up a little bit later on, just like with the paternity leave pay entitlements. Other thing in April was an organisation called the Fair Work Agency being established. It's a public authority. The idea of it is to enforce things like statutory sick pay, minimum wage, holiday entitlements, make sure that employers are paying the right levels of pay for SSP, maternity pay, these type of statutory payments. They can come into the workplace, they can interview people, examine records, and conveniently, they can also bring tribunal proceedings on behalf of workers who they feel have been wronged. I've not heard of any instances of them yet knocking on anyone's door, but just be aware that they are a genuine organisation and they could be calling to ensure that you are abiding by the law. One thing to say about it is new. It is set up and stated as being able to provide legal assistance to any person. So notionally, that could include employers, where you could perhaps ring up and say, we're not sure about the rate of minimum wage. We're paying this much. Is it right? but I'm not sure whether that would be wise personally. If you ring up saying I'm from this golf club and we're not paying the right wage, then they might come down on you like a ton of bricks. So it'll be interesting to see how this develops and exactly what role they play in this. I suppose similar to the way ACAS works at the moment, where an employee or an employer can ring up and get advice. What I'm not sure about is whether you could remain anonymous in any calls or requests for advice if you were to do that. But we'll see how that develops and continues. So we've got through the first part, which is what's in force already. We now come to stage 3 in the introduction of the changes from the Employment Rights Act. And this is the changes that are coming in October 2026. So we've only got another sort of 3 or 4 months before we see these changes happen. So first one is in relation to harassment. Those of you with a decent memory and who have been to our seminars before and read our newsletters, you'll be aware that in October 24, there was a duty introduced for employers to take reasonable steps to prevent sexual harassment in the workplace. That was designed to prevent sexual harassment from employee to employee, and it was drafted in quite a woolly way in that it didn't, in the legislation, immediately apply to harassment by a third party. And in golf club scenario, think members. So it wouldn't apply based on the absolute strict wording of the statute for harassment by a member as against an employee. But the ECHR, the Equalities and Human Rights Commission, they wrote their statutory guidance on it in a way that interpreted it quite differently, and it gives a backdoor route for that to come into play, i.e. harassment by a third party, a member as against an employee. So we should already have taken reasonable steps to prevent sexual harassment by both employees and by third parties, by members, and any other third party that visits the premises. What we have now, though, is that the bar has been raised significantly in that the duty to prevent harassment, and it relates to both sexual harassment and harassment on other bases, such as disability, sexual orientation, any of the other protected characteristics in the Equality Act. An employer will now have a duty to take all reasonable steps to prevent it. Okay, so it is just the insertion of the word all, 3 little letters, but it does have a huge impact on what you would have to do, especially if it came to being in an employment tribunal and been on the receiving end of a claim. Now, it's worth noting that this duty to take all reasonable steps is not a standalone claim. So an employee could not sit and look at your website or your handbook and say, haha, they haven't put this policy in place, that policy in place. They have failed in their duty to take all reasonable steps, and then bring a claim just for that failure to deal with documents or to provide training. It's effectively what's called a piggyback claim. So they'd have to piggyback this on the back of a claim for sexual harassment, so that it would kind of work in a way that there is sexual harassment, they brought a claim for that, and then they say, and no wonder it happened because the employer failed to take all reasonable steps to prevent it. Obviously, looking on the more positive side, if you do take all reasonable steps to prevent sexual harassment, it provides a much better workplace, which is free from discrimination and harassment, and it's one where, if you look at it selfishly, it should prevent any of these sorts of claims from happening as well. So I think that we need to look at what all reasonable steps to prevent sexual harassment will look like. And again, another little hole in the legislation is that this is due to come into force in October this year, but the regulations to tell us what reasonable steps will look like not expected until 2027, perhaps even into 2028, subject to consultation at the moment. So it is quite inconvenient that it is coming into force in October, and we're not getting the detail until much later. We do have guidance, though, from the previous bit of legislation that introduced the just reasonable steps. So we do know a little bit about what would be expected, and I would hope that everybody has been through the process from that already. First and most important thing is that you risk assess. You risk assess where there are potential problems in the organization, I suppose, as far as where sexual harassment may occur, where there are the biggest risks. Obviously, like with any risk assessment, you would then be looking to do things to eradicate or to significantly reduce the likelihood of those things happening. So when we're looking at golf clubs, I think we've probably got the bar has been quite a big risk area for sexual harassment, certainly from all the employment, from all of the member disciplinaries that we deal with. The bar seems to be a very common place for a lot of this sexual harassment to take place. So what can we do? So we've got to look at our policies and procedures that we've got in the golf club. So the equal opportunities policy is a starting point. We need to make sure that's up to date and that it covers sexual harassment. It recommends that you have a separate harassment policy, although it does say you could include that within the main equal opportunities policy, but it would have to be quite a significant part of that. It can't be just one or two paragraphs to talk about it. You've got to be going into it in quite some detail. So it's probably more sensible to have a separate bullying and harassment policy from the equal opportunities policy and make sure you cross-reference across to that. Again, we've got both such policies on the website if anybody needs to have a look at them and download them. Other things to think about are a lone worker policy, because that would help us following from the risk assessment in the bar with the lone employee working and, a member or two members who've had a few drinks. We need to look at mitigating risk there. We also see an awful lot of sexual harassment issues through social media, through WhatsApp messaging or other forms of other platforms with direct messaging on them. So again, social media policy, we need to look at making sure that's up to scratch and that deals with appropriate and inappropriate behavior for going through those platforms. And again, it's important to cross-reference these documents across to one another. Importantly, to the disciplinary procedure, to make sure, within those policies, if you breach this, then you will face disciplinary action. Another very important aspect of the steps that we should have taken already is to educate and inform the employees. So in terms of looking at it from the perspective of the victim, to make sure that they're fully aware of the grievance process and that they know how to raise a complaint, know that they'll be fully supported and protected, they'll be treated in a confidential manner. We need to make sure that they've got that reassurance there. The previous legislation for this also talked about ensuring that there was training in place for employees so they understand what they should and should not be doing. And importantly, training for managers to make sure that they know how to recognize and handle these type of complaints. So we need to make sure all of that is up to date and it does what it needs to do. Training, obviously, for these people could be done externally, it could be done internally, but we certainly have the strong suggestion here that employees should be trained in the detail of this harassment. Looking a little bit more widely, we now have that duty to take all reasonable steps. And I think that if we've got policies and procedures in place for our employees, if we've got training in place, all of the policies are well communicated and we make sure that everybody understands them. We get sign-offs to say they've read and understood them, they've been to training, and then we look at doing refreshers every year to make sure that everybody's up to speed with things. We are very likely, although we need to wait and see what reasonable steps will actually look like when it gets to 2027, 2028. We are very likely to be ticking all the boxes as far as taking all reasonable steps are concerned there with our employees. Where it gets a little bit more difficult is in relation to third parties and taking all reasonable steps to prevent sexual harassment by third parties. One of the biggest headaches, obviously, with that would be looking at what we can do to educate and to manage our members. Obviously, a lot of those policies that we've mentioned before, equal opportunities, bullying and harassment, social media, they'll go a long way to, if we ensure that they're applicable to the members, they will go a long way towards seeking to control their behaviour on that. And again, we need to make sure that we're cross-referencing and that we've got everything in terms of a paper trail from the Constitution and our disciplinary regs to make sure that we have got this all nailed down to apply to the members. Again, just like with employees, if we're thinking of taking all reasonable steps, I don't think it's any good just to send an email out saying, by the way, all members, there's a new policy out there on bullying and harassment or a new policy out there on social media, full stop. If we're looking to take all reasonable steps, I think we need to be going that step further to make sure that people have read, understood it, and given you some sort of receipt back to say that they've seen that, read it, and understood it. That would, because if you think about a worst case scenario, if you're being cross-examined by a barrister in an employment tribunal claim, one of his questions is likely to be, okay, you send out the shiny new policy that said this, that, and that. Did everybody read it? And he's there start saying, don't know. If you haven't got those receipts back to say, yes, I've read it, I've understood it, and you as a manager have made sure that each of your members has got that in front of their nose to make sure that they've seen, read, and understood it. I think that we've got a potential to ensure that we train the members as well. So is it likely that we're going to get 700 members in to a room to undertake HR training on sexual harassment? That's going to be a bit of a handful and unlikely. The legislation does say that it needs to be reasonably practicable. So I would say pulling them all into one room for training is going to be difficult and unlikely to meet the bar of what's reasonably practicable. But what might be reasonably practicable would be to buy a webinar in from somebody like me who gives a half an hour talk on a video, and then you bung that out to all of the members. Again, make sure that you get the read receipts back from them to say, I've got it, I've watched it. There may be more advanced electronic things that you can do that show that somebody's actually sat and watched the video of the training. That would be going towards taking all reasonable steps as well. As I say, we're still waiting to find the detail out, but that's where I'm thinking we need to be going with this. Other things to consider in the golf club in relation to third parties, you will have other people visiting the premises. You'll have, builders and plumbers, electricians, other workmen coming on site who are not members and over whom you have a lot less control. There, I think we need to be thinking about, similar to when you visit a hospital or a doctor's surgery or dentist, there'll be signs up on the wall saying we don't tolerate abusive behaviour towards our staff. Do we need to be looking at having signage along those lines to say we don't tolerate sexual harassment or harassment of any kind of the staff? That might be an answer to taking those reasonable steps. If we've got contractors, very often I understand that you guys will have them, you put the health and safety policy under their nose before they come on site, get them to sign off on the fact that they've read and understood it. I think that's similar thing with equal opportunities policy and the bullying and harassment policy to make sure they've read and understood that. I would say you might want to be going a step further so that if you've got a written contract with, the builder to come and build an extension, that you make it a term of his contract with the club that he abides by this. Yeah. And then if it doesn't happen, if something terrible goes wrong, you've got provisions in the contract there to do something about it. You've also got another group of people who come on site, which are visitor golfers. And again, a lot of the time, you will see people send out terms and conditions with bookings for visitors. I think we need to be starting to include that. I know people are always very keen to make sure that the dress code gets sent to visitors. If we can do that, we can certainly make sure that we're putting stuff in front of them to prevent sexual harassment. So we need to be taking steps in relation to them. It's not going to be reasonably practicable to have them sit through half an hour's training before they go onto the golf course or into the clubhouse, but certainly we can do things with documentation that we send to them in advance. So another thing for October is trade union matters. Most of it's not going to apply to golf clubs, but the one that does, which is very important, is that you will have to issue your workers with a statement of a right to join a trade union. So that might be something that just gets inserted into a contract of employment, or a letter as an addendum to the existing contract of employment to say you've got the right to join a trade union. Other interesting bit is that at the moment, if somebody wants to bring an unfair dismissal claim, they have 3 months from the termination date to bring that claim. In the case of a discrimination claim, it's 3 months from the date of the discriminatory act. That's now going to be increased to 6 months because that's what they are planning to do, and it'll give employees just a little bit more time to get some advice. Employment tribunals historically have been really, really strict with time limits for bringing claims. And it may be as a result of some claims missing out by 24 hours, or in some cases an hour to the deadline, that they want to give a little bit more time and a little bit more leeway to people to be able to bring claims. Whilst those are there as 3 month and 6 month time limits, it can be extended by a month whilst the employee goes through the compulsory early conciliation period with ACAS. So that will extend these time limits beyond 6 months in practical terms. We've got through stage 3 now. Hopefully it's all sinking in. We now come to a couple of the biggies, which are the unfair dismissal changes and the fire and rehire protections. So turning first to the unfair dismissal, this was the main reason why the Employment Rights Act had such a difficult passage through Parliament. The government originally wanted to make it a day one right to be able to bring an unfair dismissal claim. And the House of Lords did not want that. And that's the reason that it was bounced backwards and forwards between the two houses. Eventually, they've agreed on 6 month qualifying period. So right now, if somebody wants to bring a claim for unfair dismissal, they need to have 2 years of continuous service. Once we get past the 1st of January, they'll be able to bring an unfair dismissal claim after 6 months of service. And if they had, say, 2 months before the 1st of January, that service will count, so they'd only need to work for you for another 4 months in the new world, if you like, to attain their 6 months of service. So that will be coming into force, and is something that, as managers, we need to think about. Obviously, as well as giving you as managers more protection from your golf club, we need to think of it from a management perspective as employers. The realistic, practical, main things here are there's no statutory probationary period introduced. In the early stages of the consultations with this, there's going to be a statutory minimum probationary period. That's not there anymore. So I think what we need to do as employers, just like we probably do with new starters now, is to ensure that we have a probationary period for new starters. But importantly, that we monitor that. Yeah, we've got to diarise, monitor it, and manage it in a very strict way to make sure that we've got the right people in place so that after 3 months, we're having review meetings, appraisals, that sort of thing, to make sure that the person is fitting in and that they're doing the right things as far as we're concerned, because we don't want them to drift past the 6-month qualifying point without having had any sort of formal review to determine whether or not they're going to continue in their employment. So that's one of the most important things. The other big thing for this is you will have people on the books at the moment working for you who have less than 2 years of continuous service, but who will have more than 6 months. So we need to consider whether there's anybody who's perhaps a little bit iffy, not performing to the required standard, might be just a little bit naughty, but not naughty enough to dismiss at the moment. We need to take steps to manage those people and think about a departure for those people before we get to the 1st of January. Yeah. So that's something that is certainly worth a review over the next month or so. If you are thinking of dealing with anybody in those circumstances, make sure you do it well within sort of November or even October, because we don't want to be getting to close to the deadline in January and find that for whatever reasons with delays that we creep over the change in legislation date. The other thing that's changing there is the removal of the compensatory award cap. So at the moment, the most that an employee can get if they bring an unfair dismissal claim is £118,233, which is a lot of money. The way in which it works, though, is that the tribunal award compensation not as a punishment, but they award it for what the person has actually lost. So their financial loss is the result of being dismissed unfairly. So if they earn £20,000 a year, the employment tribunal will say, okay, you've been dismissed unfairly. How long before you find another job paying the same or more money than you were paid? Now, if they assess it at 6 months before they find another job, then that will be the limit of the compensation that they get for unfair dismissal. It would be 6 months losses under the old pay scale at £20,000 a year. So a lot of employees are unlikely to get anywhere near this compensatory cap. It's only going to be, real big earners that get near this, who are earning well into 6 figures. If an employment tribunal is saying, well, we don't think you'll get another, even if they're on £120,000, they're going to have to say, we don't think you'll find another job for 12 months before they get anywhere near this cap. So I don't think in reality that's going to have much of an effect on how we work in most situations. Right, the next big change is in relation to fire and rehire. That's what it's colloquially referred to as. In the world of the Employment Rights Act of 1996, an employment law, we've got 5 potentially fair reasons for dismissing employees. So this is once they get 2 years of service, or under the new system in January, once they get past 6 months of service, you can only dismiss for 5 potentially fair reasons. So we've got misconduct, been around for years. We've got capability, which has 2 arms to it. One is where somebody's on long-term sickness absence. The other is where they're not performing to the required standard and you put them on a performance improvement plan. So misconduct, capability. We've got redundancy is the third one. Fourth one is what's called a statutory restriction. So that's where easiest way to give an example is if somebody's employed as a driver, then they were to lose their license for drink driving or whatever they lose their license for. We then say, sorry, we're restricted by statute, we're restricted by the law from employing you anymore because you don't have a driving license and you can't drive. So that would be a potential fair reason for dismissal. There is a procedure that flows from that, but we'll not get into that. The fifth one is what's called some other substantial reason, and that's where the fire and rehire comes in. And it's essentially where an employer has an employee with, or a number of employees on an existing contract of employment, and the employer wants to make changes to that contract of employment. So they might say, one of the easiest things to give by way of an example is, let's say the greenkeeper has an entitlement for whatever reason under his contract of 10 weeks of holiday per year. The employer might say that just doesn't work for us because he's away too much. We need him here with less holiday. So you might want to change the contract to reduce holiday entitlement to a lower level that's workable. The way the law works now and how it has worked for the last 40 years or something, well established in case law, there's a code of practice that reflects it. It says that you should first of all have a consultation with the individual, try and get them to agree voluntarily to it. If you have a sound business reason for making the change to the contract, so it might be money saving, it might be, just generally making some efficiencies within the business. As long as you've got a sound business reason and you go through the proper consultation process with them, you can ultimately, at the end of that process, terminate the existing contract and then offer them a new contract starting as soon as the old one finishes. So it would end on a Friday, but starting Monday, there's the new contract with the new terms. Ideally, they'll agree during the consultation process, but if not, you've got the ability for this to be a potential fair dismissal under the existing law. And it all hinges on having just a sound business reason and following the procedure of consultation. That's now going to change. Okay, so when this does change, which will be starting January, and it's still subject to an open consultation. So a lot of the detail we don't have just yet, but it is set to take place on the 1st of January. What they're going to say is, first of all, you can only make these changes. I mean, you can consult with people and agree changes voluntarily. That's fine. But if it relates to a restricted variation and they refuse to agree to that change in the contract, it's going to be an automatic unfair dismissal. Okay? What it says as well is that you must have, under the existing system, you can just have a sound business reason for it, making efficiencies, saving some money, whatever you might have as a sound business reason. Under the new system, the bar is much higher. It's going to be one where there's basically no reasonable alternative, which it looks as though that's going to mean that business is close to failing unless we make the change. So it's a much higher bar for employers if they want to make these changes. It also says that these restricted variations, they're going to relate to all of the kind of important things, for want of a better description, that you're more than likely to want to change in an employee's contract. So restricted variations are what they call matters relating to core contractual terms. So it'll be things like pay, their working hours, annual leave, pension rights, shift patterns. Those are what are going to be restricted variations. So we're going to have a huge restriction on what we can do as far as changing contracts are concerned if the employee does not agree to it. You will be able to potentially go through this process, terminate the contract and issue a new one if it relates to a non-restricted variation. And that is where you want to put changes through relating to the place of work, the location, their job duties, or their reporting lines. So things that aren't really probably going to have that much of a difference on streamlining and economies of scale and what have you. It's going to be, realistically, if you need to change where you operate from, you can potentially go through this process and force the change through. So that is going to have an impact on where we get to with being able to change employees' contracts. So similar to the unfair dismissal pieces of legislation with the timings, I think, again, we need to look at reviewing contracts at the moment and get things done before we get near to the 1st of January. If we have unfavourable terms in contracts, it's going to be much easier to make those changes if employees don't agree to them before we get past the 1st of January. So it's again another job for the to-do list. Have a look if there's anything there that's looking like it's not going to be particularly good for the business in future. Remaining changes for 2027, there are some changes to collective consultation. Again, that's in large-scale redundancies when we've got more than 20 employees. So we don't need to get too heavily into that unless you've got a bit of a nightmare scenario coming off. The big changes I mentioned before relate to 0 hours workers. We'll look at that in a little more detail just now. What is going to change are two main things. One is that the employer will have a duty to offer guaranteed hours to the 0 hours worker. And we refer to this as 0 hours worker, but the definition in the Employment Rights Act also applies to what they call low or lower hours workers. So somebody who's only on a handful of hours per week. So it doesn't necessarily have to be on a 0 hours contract. It could bring into frame these low number of hours per week workers. The duty is to offer them guaranteed hours that reflect what they have actually worked in a reference period. And that reference period, again, subject to consultations and what comes further down the line, looks likely to be 12 weeks. So if they've worked for you for 12 weeks, they've got an average of 6 hours a week. At the end of that 12-week reference period, you'd be under a duty to offer them guaranteed hours going forward as basically a permanent contract. In the earlier iterations, and this was the other big reason why the Employment Rights Act stalled at parliamentary level, was that it went up to the House of Lords and this duty changed. So rather than being a duty to offer the guaranteed hours, the employee had the right to request it, which was, in my opinion, a much better way of working it, because it then also gave the employer the ability to refuse it, and it was looking like it would mirror the flexible working provisions, where there would be a list of statutory reasons for refusing it if it didn't work for the employer for whatever reason, such as we don't have this work available in the winter, this is seasonal work, all the hours are here in the summer, so it's not going to work in the winter, you would be able to refuse. But unfortunately, that's not the case. The duty is to offer the guaranteed hours that reflect what they have worked in the reference period. Yes, the employee can refuse them, which may well happen practically in a lot of cases, especially if you've got students who are going back to university or people who have other things that they do in the winter. So that might be a saving grace for it. There was talk at one point as well about having a qualification period for this. So somebody might have to have worked for you for 6 months before they get this obligation imposed on the employer. That doesn't look as though that's going to come through either. So it does look, unfortunately, as though we're going to have this duty to offer the guaranteed hours once we get to the 12-week period. If they were to refuse that after the first 12-week reference period, when you get to the next 12-week cut-off point, you're under a duty again to offer the same thing. So that's going to make life a little bit difficult. We do have to wait to see how it's going to be framed in detail with further consultation and the further detail of the statutory instrument to come. When I'm doing these presentations all around the country, people are saying, what about this? What about that? What about the other? Most of the ideas, most of the cunning plans that managers are coming up with don't look as though they're going to work, unfortunately. I think the best thing that most people are looking at is when you have work available in the summer, rather than it being casual in that it can flex up and down, most people are thinking they're going to offer a fixed term contract for 12 weeks for the summer period at 6 or 7 hours per week or whatever it is that you think would fit in, rather than it being this 0 hours thing. Then the fixed term contract would then expire after that 12-week summer period, and you're under no duty to then offer them anything going forward. So that may be the answer, but at the same time, you're committing to definitely having 6 hours a week or however many hours you offer on that fixed term contract. Getting back to our casual workers, our 0 hours people, there'll be an entitlement to get reasonable notice of shifts and reasonable notice if shifts are changed or cancelled. That reasonable notice period is likely to be 1 week, but we don't yet have that confirmed for sure. If you don't give that reasonable notice of changing a shift because, the visiting party cancel or because it's thunder and lightning and you don't need catering staff that day, if you don't give reasonable notice, they're entitled to compensation, which is going to be the pay that they would have received for that shift anyway. So we do have some significant change in the offing for 0 hours contracts. When Labour and the trade unions were on the manifesto trail, they were talking about banning 0 hours contracts altogether. They obviously haven't done that, and I think part of that was through the process with the consultations before it got to this stage, where it was recognised that these contracts do actually work for some people. But Labour and trade unions seem to believe that they are exploitative, and they have done this. And as we've seen from a lot of the suggestions from managers around the country, it may well be that they become a thing of the past. And you would look to having to commit to fixed term working for the summer period in order to engage people. So that's where we get to. I mean, within a fixed term contract, you may be able to have a degree of flexibility. And again, this is another possible workaround where you have, just like you might have for other employees, where you have a total number of hours for the fixed term. So you say you're employed for 12 weeks, we'll employ you for 300 hours in total, and you can then flex using the shift patterns each week as you go along, to fulfill the full contractual hours for that. But again, we need to wait and see what comes further down the line. Flexible working, there will be changes to this. They're not groundbreaking. It's the exact same flexible working provisions that we've had for a lot of years. But all they're changing is that if an employer is going to refuse the request for flexible working, it has to be reasonable, which I would argue pretty much every refusal of a request, as things stand at the moment, is reasonable. But the employers will then have a further duty to state in their written reasons for refusing it why it is reasonable. So there's still the same list of statutory reasons for refusal. And so if you fit one of those, it's likely to be reasonable, but you've just got to set it out in a little bit more detail. And the thinking there is that you've just got to justify it a little bit more, and you may be subject to further questioning and cross-examination if and when it gets to an employment tribunal, which hopefully it would never do. A couple more family rights that are in the offing. There's going to be further protections during pregnancy and maternity leave, and upon return to work for people who take maternity leave and family leave. So that will be something, again, that we get detail on, but I would imagine it's going to probably put a period of time after return from maternity leave or other parental leave, family leave entitlements, put a time period on that to make it an automatic unfair dismissal, I would imagine. But again, we're waiting for detail on it. The other thing that's going to change is the introduction of bereavement leave. At the moment, there's an entitlement to bereavement leave for parents who lose a child under 18 or a stillbirth after 24 weeks. This will now be extended to bereavement leave for employees for other members of their family. They're yet to define how wide that family circle will be, but I would imagine that will follow the definitions that are there in a lot of the existing legislation, such as the right to dependent leave, where the sort of immediate family is defined within the legislation. I've listed there the various consultations that are ongoing. We needn't go into those. We've mentioned most of them as we've gone along. We then get to the final bit, which is the summary and top tips bit, which I've mentioned as we've gone along. I think we need to go away and risk assess key areas from what has come into force, what is due to come into force. Key there are the fire and rehire provisions. So we need to look at contracts, see if there's anything that we might want to change before we get close to the 1st of January. Similarly, in relation to unfair dismissal, have a look at timescales, length of service for employees, see who's getting close to their qualifying service for unfair dismissal, determine whether or not such people need to be exited from the business sooner rather than later, so we don't get them to the 1st of January and find that we're having to go through a much more detailed procedure, because once you get to only being able to dismiss them for the 5 potentially fair reasons, there is a much more complex and lengthy process for and procedure for dismissing in those circumstances, where it's much more straightforward to deal with dismissals prior to them having that right to claim unfair dismissal. And again, tying in with that, for once we get past the 1st of January, we need to look at systems being in place to monitor probationary periods. And finally, in relation to that risk assessment side of things, it's the harassment stuff I think that we need to really get on top of. Obviously, training for managers and for staff, and then we need to have really put the thinking caps on about what steps we might want to put in place to hit that definition of taking all reasonable steps in relation to members and other third parties who may be visiting the premises. And as I say, unfortunately, they're not giving us the detail of that until 2027 or beyond. So there's an element of drawing on what we know now for the taking of reasonable steps and building on that for taking all reasonable steps after that. So that's me done. Hopefully, some of that's gone in. We've broken it down, as I say, into stages, and yeah, we just need to take it step by step, deal with each thing, and hopefully it will be a fairly painless process. So thank you very much.
Thank you very much, Alistair. As we said at the start of that session, we're going to go into some questions now if anyone has any. So just before I stop the recording to enable us to do that, thanks very much for presenting for us today, Alistair, for those watching this on the recording.
No
And
problem.
yeah, we'll see you all very soon. Thank you.